Good morning, friends. Welcome back to Advocate Jayashree's Musings on Law. Today, we'll be seeing a little about the term intention, which plays a very important role in law. Intention is what we want to do, what we would like to do, what we wish to do. This is the literal meaning of intention. Something I do intentionally, that means what? I want to do it, so I am doing it. That is known as intentionally. What I want to do can either be something which is positive or something which is negative. So, whether it is positive or negative, the term intention remains the same for both. That is what I wish to do. What I wish to do is the intention. Now, when we look at it from the lens of law, how do we see it? I think it is of common knowledge when something happens, some crime is committed, then immediately we look for intention for the crime. As all of you know, the latest a murder of a newlywed husband, right, by the wife in the Northeast. I don't need to go into the details because it's all over the social media as well as papers, newspapers. So the newlywed couple go on a honeymoon. The wife murders the husband with the help, of course, of two or three people more. Okay, so immediately as soon as we see the wife, it is not necessary that we should be lawyers or we should be judges or we should be the police to immediately look for the intention. As soon as we read the headline, you see, why did she murder? They are newly married couple. Okay, a little more into the marriage we can understand, or probably it is not the rule, it is the exception, right? So immediately we look at the intention. Why did she kill him? What was the necessity? What did she want? These are the questions which immediately forms even in the minds of non-legal people. So obviously when it is there in the minds of the non-legal people, the legal people who are associated with law more closely, obviously the mind will look for intentions. So in a criminal situation, in a crime, we automatically look for intention. The judges also look for the intention and we see whether it is positive or negative. Of course, in crimes, it is never a positive intention. It is always a negative intention. If there was a reason for the lady to kill the man, that is the wife to kill the husband, there was an intention in her mind. She wanted him killed. Why she wanted him killed? There are various stories. I don't think we need to go into all those details. What I'm trying to say is there was some reason to kill. So she murdered him. Now, this is as far as the crime is concerned. This is as far as criminal law is concerned. Intention plays a very, very important role in a criminal case. Because the level of intention, when we say intention plays an important role in criminal laws, we look at the extent of intention. Was there an intention is the first question. If there was an intention and it is very clear, then we go into the extent of intention. Why? The reason behind it and whether the reason was justified or not is also an important part in the criminal laws. Why we say, is it justified or not? Of course, when I have a bad intention, when I have a negative intention, what is the necessity of seeing whether that intention was necessary or not? We know it's a negative intention. Why should we look into why it is necessary or not? Is it justified or not? Why should we go into that? Because the criminal laws once again give a section, I should say give a provision for something called self-defense. Self-defense is done with an intention, again it's negative. Of why we call it as negative is because the intention is for harming or hurting the other person or animal or bird or thing or whatever thing, it doesn't come. Anyway, here we look at persons. So negative intention, as far as we say self-defense, again it is with the intention of harming or hurting the other person. But why? self-defense is taken as an exception. See, if somebody attacks a person and the person in turn attacks the attacker, then it is taken as it is done in self-defense. Why? Suppose somebody is walking on the road in the dead of the night or probably in broad daylight nowadays. Okay? A robber just robs something from the woman or man and runs away with it. Of course, in motorcycle or car or whatever, nowadays various modes of transport. So, if the robber just goes away from the place, then immediately, or if the robber just stays put there, and the person who is being attacked in turn attacks the robber, okay, in turn attacks the robber, then we can say that the person acted in self-defense. The robber tried to rob him or her, so the person, the victim, attacked the robber in return. Or probably there was a try to attempt to murder or try to cause some injury to the person. So, in turn, in order to save oneself, the victim attacked the attacker. Okay, then we can say that the intention was self-defense. Even though it is a negative intention of harming, we can say it is the intention of self-defense. Now, when does it become a little more than self-defense? Only when the intention becomes a little more than self-defense, then it amounts to a crime. A robber robs a person. In turn, what does the victim do? He kills the robber. Now, robbing is different from killing. If the robber had tried to kill the victim, then the victim, of course, killing the robber is too much, but still we can say that it was in self-defense in certain circumstances. But if the robber just came to rob and he robbed the victim, and in turn the victim killed him out of anger or then he cannot claim that I did it out of self-defense. Why? Because there was never a threat to being killed. So, the offense which was committed, that is robbery, is lesser than the offense which is being committed by the victim. Therefore, the offense committed by the victim becomes a crime. This is how intention is differentiated as far as self-defense and the actual crime is concerned. Okay. So, when the self-defense, the intention in self-defense is more than what is required, then it becomes a crime. It can be considered as a crime by the law. Usually it is considered as a crime. Okay. Now we will go to civil cases. Is there any intention in civil cases? Is intention necessary in civil cases? No. Intention is not necessary for civil cases as well as far as property law, divorce law, personal laws. These are all concerned. As far as these are concerned, these laws are also coming under civil laws. So, as far as these laws are concerned, it is not necessary for intention to be a part of the, let's say, some violation. Okay. Suppose there has been an accident and the person against whom the accident has been done is claiming for compensation before the Motor Vehicles Tribunal. That is where we file a case for compensation in case of accident cases. There it is not necessary for the person who has been injured to prove that the person who came from the opposite direction and dashed against him caused the accident. It is not necessary that he should prove that the person who caused the accident had an intention to cause the accident. He can just say that the other person came in a careless manner, reckless manner and caused the accident. Or he was just going past the victim, the person injured, and he just dashed against the victim's vehicle or victim's limbs or whatever it is, and the person just went away. So here intention is not at all taken into consideration for calculating the compensation. It's only the injury. Same way when we look at property laws also, it is not the intention to cheat the other person which is taken into consideration. It is the very fact of the possession or whatever is the violation which has been done, say encroachment or some easementary right violation, whatever or even in a partition case, if the partition has been done without including the actual other co-personal means the person who is entitled. So in all these cases, we don't, even in divorce law, we don't care. When we file a case for divorce, we don't look at the intention of the husband or the wife. Okay? So intention is not necessary in a civil case. But when we go to the contracts, when we go again to the criminal side of the civil cases, that is, when it comes to accident case, the police obviously file an FIR saying that so and so accident has been caused on so and so road at this time and all that, right? Same way when we go to divorce law and there has been a allegation of domestic violence or something like that, something violence has happened, in that case again the criminal case will be registered. Okay, even though there is a case for divorce going on, domestic violence case will be registered and that will become a criminal case. So civil case and criminal case on the same grounds can be filed together. This is what one more thing which has to be needed. And even in contracts, we look at the part where violation has taken place, we claim for compensation. We cannot claim for penalty normally, right? So even in contract cases, when we file the civil case for violation of the contract and we ask for compensation, but if the contract violation involves cheating, then we can file a case even for cheating under the criminal laws. So when it comes to civil laws, civil cases having the same grounds but filing of criminal cases on the same grounds, then the criminal part of the say the contract or the divorce or the accident, the criminal part of all these things will need intention. Intention will be looked at in these cases. But when we are purely deciding a divorce case or accident case compensation or compensation for violation of contract, in breach of contract I should say, in all these things, of course the intention is not taken into consideration. Same subject matter, but when it comes to criminal laws, then we take intention into consideration, and intention forms a very, very important ingredient in the deciding of criminal laws. When we go through the Contract Act, we have something called the mens rea. When we go through the Indian Penal Code, which of course has been a little more into Indian law nowadays, and I really appreciate that. So even when we get into the penal code sections, we have something called the mens rea. Mens rea means the intention. So it is common for civil as well as criminal cases, but intention is considered purely in criminal cases. So this is the importance of intention. I am extremely sorry. This is the importance of intention. In case any of you file a civil case or a criminal case and you are worried about whether intention is required, as I see, many people get confused. They say, no, he wanted to cheat me. Then why are you not getting him punishment in civil case? See, civil case doesn't involve punishment. It only involves compensation. It only involves the torts, that is the civil wrongs, correction of civil wrongs. It doesn't involve any punishment. Therefore, in civil cases, you will not get punishment. But intention is important if you want to file the same thing on the grounds of criminal law. Let's meet in the next video. Thank you.